Good morning. This is Ron Mickens. You know the topic. Fraud upon the court. The truth is in the details. Our right to travel. This is part C. So let's get right into it. Regulation. In addition to the requirement that regulation governing the use of the highways must not be violative of constitutional guarantees, the prime essentials of such regulations are reasonableness, impartiality, and the fairness or certainty. And, moreover, a distinction must be observed between the regulation of an activity which may be engaged in as a matter of right and one carried on by government sufferance of permission. Davis versus Massachusetts. One can say for certain that these regulations are impartial, since they are being applied to all, even though they are clearly beyond the limits of the legislative power. However, we must consider whether such regulations are reasonable and non-violatives of constitutional guarantees. First, let us consider the reasonableness of this statute requiring all persons to be licensed. In determining the reasonableness of the statute, we need only ask two questions. Does the statute accomplish its stated goals? The answer is no. The attempted explanation of this regulation to ensure the safety of the public by ensuring as much as possible that all are competent and qualified. However, one can keep his license without resetting from the time she is first licensed until the day she dies, without regards to the competency of the person, by merely renewing said license before it expires. It is therefore possible to completely skirt the goal of this attempted regulation, thus proving that this regulation does not accomplish its goal. If an analysis were compiled of all accidents between those individuals having a license and those who do not, it would reveal that the highest percentage of accidents were had by those who had license. A license does not, in and of itself, guarantee the safety of the general public, much like the license to practice law or medicine assure that only competent lawyers and doctors ply their trade. A review of the annual malpractice lawsuit is the only proof necessary to establish that it does not. Furthermore, by testing and licensing, the state gives the appearance of underwriting the competence of the licensee and could therefore be held liable for failure, accident, etc., caused by licensees, as the state has certified through the issuance of the license that the individual is competent. Is the statute reasonable? The answer is no. This statute cannot be determined to be reasonable since it requires to the citizen to give up his or her natural right to travel unrestricted in order to accept the privilege. The purported goal of this statute could be met by much less oppressive regulations, i.e. competency tests and certificates of competency before using an automobile upon the public road. But isn't this what we have now? The answer is no. The real purpose of this license is much more insidious. When one signs the license, she gives up her constitutional right to travel in order to accept and exercise a privilege under contract. After signing the license, a quasi-contract, the citizen has given the state her consent to be prosecuted for constructive crimes and quasi-criminal actions where there is no harm done and no damage property. These prosecutions take place without affording the citizen their constitutional right and guarantee such a right to a trial by jury of 12 persons and the right to counsel, as well as the normal safeguards such as proof of intent, a corpus delicti, and a grand jury indictment. These constitutional prosecutions take place because the citizen is exercising a privilege, has given his or her implied consent to legislative enactment designed to control interstate commerce, a regulated enterprise under the police powers of the state. We must now conclude that the citizen is forced to give up constitutional guarantees of right in order to exercise his state privilege to travel upon the public highways in the ordinary course of life and business. Surrender of rights. A citizen cannot be forced to give up his/her rights in the name of regulation. The only limitations found restricting the right of the state to condition the use of the public highways as a means of vehicular transportation for the compensations are that the state must not exact of those it's permitted to use the highways for hauling for gain, that they surrender any of their inherent U.S. constitutional right as a condition precedent to obtaining permission for such rights. Okay? Stevenson versus Benford. If one cannot be placed in a position of being forced to surrender rights in order to exercise a privilege, how much more must this maxim of law then apply when one is simply exercising a right? To be that statute which would deprive a citizen of the right of a person or property without a regular trial according to the course and uses of the common law would not be the law of the land. That's Hoke versus Henderson. We find it intolerable that one constitutional right should have to be surrendered in order to assert another. Since the state requires that one give up rights in order to exercise the privilege of driving, the regulation cannot stand under the police powers, due process, or regulation, but must be exposed as a statute which is oppressive and one which has been misapplied to deprive the citizen of rights guaranteed by the United States Constitution and the state constitution. Taxing power. Any claim that this statute is a taxing statute would be immediately open to severe constitutional objections. If it could be said that the state had the power to tax a right, this would enable the state to destroy rights guaranteed by the Constitution through the use of oppressive taxation. The question herein is one of the state taxing the right to travel by the ordinary mode of the day, and whether this is a legislative object of the state taxation. The views advanced herein are neither novel nor supported by authority. The Supreme Court has repeatedly considered the question of taxing power of the state. The right of the state to impede or embarrass the constitutional operation of the U.S. government or rights which the citizens hold under it has been uniformly denied. The power to tax is the power to destroy. And if the state is given the power to destroy rights through taxation, the framers of the Constitution wrote that document in vain. It may be said that a tax of $1 for passing through the state cannot sensibly affect any function of the government or deprive a citizen of any valuable right. But if a state can tax a passenger of $1, it can tax him $1,000. Crandall versus Nevada. If the right of passing through a state by a citizen of the United States is one guaranteed by the Constitution, it must be sacred from state taxation. Therefore, the right of travel must be kept sacred from all forms of state taxation. And if this argument is used by the state as a defense of the enforcement of the statute, then this argument also must fail. Conversion of a right to a crime. As previously demonstrated, the citizen has the right to travel and to transport his property upon the public highways in the ordinary course of life and business. However, if one exercises this right to travel without first giving up the right and converting that right into a privilege, the citizen is by statute guilty of a crime. This amounts to converting the exercise of a constitutional right into a crime. Recall the Miller versus United States and Sherrod versus Cullen quote. The state cannot diminish rights of the people. Hurtado versus California. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda. Indeed, the very purpose for creating the state under the limitations of the Constitution was to protect the rights of the people from intrusion, particularly by the forces of the government. So we can see that any attempts by the legislature to make the act of using the public highways as a matter of right into a crime is void upon its face. Any person who claims his right to travel from the highway and so exercise that right cannot be tried for a crime of doing so. And yet, this sub juris stand before this court today to answer charges for the crime of exercising his right to liberty. As we already shown, the term drive can only apply to those who are employed in the business of transportation for hire. It has been shown that freedom includes the citizen's right to use the public highway in the ordinary course of life and business without license or regulation by the police powers of the state. Title of nobility. The Constitution of the United States of America at Article 1, Section 10, Clause 1 prohibits the granting of a title of nobility. No state shall grant a title of nobility. Since the granting of a title of nobility is absolutely prohibited, this court lacks subject matter jurisdiction to enforce title of nobility and its attendance rules and regulations. The Utah Supreme Court has stated that the ability to drive a motor vehicle on a public roadway is not a fundamental right, but a revocable privilege. The distinctive appellation, designation, or title, driver, is a title of privilege, a title of noble privilege, a title of nobility. In the words of Thomas L. Wilmore, City Attorney for the City of Templeton, Utah, a title of nobility is defined as to nominate to and order a person to whom privileges are granted. Objections to a title of nobility arises from the special privileges that attach to the title rather than to the title itself. Words and phrases, Volume 8A, page 40. A driver's license is a privilege which is granted by state, a municipal corporation. In other words, to obtain a driver's license is not to be nominated to and order a person known as a driver and be granted the special privileges that attach to the title. The United States Constitution at Article 1, Section 10 prohibits states from granting a title of nobility, a driver's license, and its attendance rules and regulations. Pursuant to City of Salina versus Weinstein, the driver's license and its attendance rules and regulations are by definition a title of nobility. Article 1, Section 10 of the United States Constitution prohibits the states from granting title of nobility. The courts lack subject matter jurisdiction to enforce upon the defendant a title of nobility. What is prohibited to the state is forbidden to the court to enforce. Therefore, the accused requests the court to make a legal determination as to what is a title of nobility. The following case law will define a title of nobility for the court to use to make its determination. The following quote gives the answer. Nobility, an order of man in several countries to whom special privileges are granted at the expense of the rest of the people. Bobier's Law Dictionary. To confer a title of nobility is to nominate to an order a person to whom privileges are granted at the expense of the rest of the people. It is not necessarily hereditary, and the objection to it arises more from the privilege supposed to be attached than to be otherwise empty title or order. Horse versus Moses. Bobier's Law Dictionary. These competent terms, privilege, honor, and emolument, are collectively in the term of title of nobility, and government-granted entitlement privileges such as a driver's license and its privileges are obviously noble entitlements and franchises, as pointed out by Richard B. Stewart, left-wing politician, Rhodes Scholar, and Harvard law professor. The third great innovation in American administrative law, which has largely occurred during the past 20 years, extended the procedural controls and principles of judicial review developed in the context of regulatory decision-making to the operations of the welfare state, including programs of government insurance and assistance, government employment decisions, and the administration of government grants and contracts. Under traditional private law principles, these benefits were privileges and not rights because their withholding did not constitute the commission of a tort or other natural law wrong against a disappointed applicant or terminated recipient. With the growth of the post-World War II welfare state, the distinction between rights and privileges gradually eroded. Statutes conveying these various benefits and advantages were held by court to create entitlement. The limits of administrative law in the courts. Separation of power. Final report on the 1983 Chief Justice Earl Warren Conference on Advocacy. The Constitution for the United States of America, at Article 1, Section 10, Clause 1, mandates no state shall grant any title of nobility. The establishment of the prohibition of titles of nobility are perhaps greater securities to liberty and republicanism than any it contains. The National Constitution. Nothing needs to be said to illustrate the importance of the prohibition of title of nobility. This may truly be denominated the cornerstone of Republican government. For so long as they are excluded, there can never be serious dangers that the government will be any other than that of the people. Danger equal nobility government, that of the police state. The Federalist Paper, Alexander Hamilton. A title of nobility is privilege of license and license of privilege. Otherwise, such title of nobility ceases to exist without such privilege of license and license of privilege. A license to drive is a title of nobility in that it is a special grant of privilege to use vehicles upon the public highways and roads. So says the Utah Supreme Court, cited in Salina versus Weston. The state grants title of nobility when it takes away a natural existing public or private right, forbidding a natural activity or occupation to all, then turns around and specially grants it back to a few or many the special privilege to engage in that activity or occupation, and requiring the obtaining of a title of noble privilege, driver's license, license plate, to drive vehicles, and obeying attendant nobility rules as applied to the accused. Contrary to the Constitution for the United States of America mandate, Article 1, Section 10, Clause 1, no state shall grant any title of nobility. Hence, all attendants, nobility, traffic rules, regulations, and penalties made pursuant to such is to the contrary of the res judicata mandate of the Constitution of the United States of America, and is notwithstanding and void by mere operation of law upon this record as applied to the accused. Hence, the courts lack subject matter jurisdiction because of the prohibition of titles of nobility, attendance rule, regulations, and penalties. Conclusion. It is the duty of the court to recognize the substance of things and not the mere form. The courts are not bound by mere form, nor are they to be misled by mere pretenses. They are at liberty. Indeed, they are under our solemn duty to look at the substance of things whenever they enter upon the inquiry whether the legislature has transcended the limits of its authority. If, therefore, a statute purported to have been enacted to protect the public safety has no real or substantial relation to those objects, or is a palpable invasion of right secured by the fundamental law, it is the duty of the courts to so adjudge and thereby give effect to the Constitution. It is the duty of the court to be watchful for the constitutional right of the citizen and against any stealthy encroachment thereon. Board versus United States. No higher duty of this court exists than to recognize and stop this stealthy encroachment which has been made upon the citizen's right to travel and to use the roads to transport his property in the ordinary course of life and business. Further, the court must recognize that the right to travel is part of the liberty of which a citizen cannot be deprived without specific cause and without the due process of law guaranteed in the Fifth Amendment. The history of this invasion of citizens' right to use the public highways shows clearly that the legislature simply found a henceforth untapped source of revenue because greedy and attempted to enforce a statute in an unconstitutional manner upon those free and natural men and women who have a right to travel upon the highway. This was not attempted in an outright action, but in a slow, meticulous, calculated encroachment upon the citizen's right to travel. This position must be accepted unless the prosecutor can show his authority for the position that the use of the road in the ordinary course of life and business is a privilege. To rule in any other manner without clear authority for an adverse ruling will infringe upon the fundamental and basic concept of constitutional law. This position that a right cannot be regulated under any guise must be accepted without concern for the monetary laws of the state. Disobedience or evasion of a constitutional mandate cannot be tolerated, even though such disobedience may, at least temporarily, promote in some respects the best interests of the public. Economic necessity cannot justify a disregard of constitutional guarantee. Constitutional right cannot be denied simply because of hostility to their assertions and exercise. Vindication of conceded constitutional right cannot be made dependent upon any theory that it is less expensive to deny them than to afford them. Therefore, the court's decision in the instance cases must be made without the issue of cost to the state being taken into consideration, as that issue is irrelevant. The state cannot lose money that it never had a right to demand from the sovereign people. Finally, we come to the issue of public policy. It could be argued that the licensing scheme of all persons is a matter of public policy. However, if this argument is used, it too must fail, as no public policy of a state can be allowed to override the positive guarantees of the Constitution of the United States. So even public policy cannot abrogate this citizen right to travel and use the public highways in the ordinary course of life and business. Therefore, it must be concluded that we have repeatedly held that the legislature may regulate the use of the highways for carrying on business for private gain, and that such regulation is a valid exercise of the police power. The act in question is a valid regulation, and as such is binding upon all who use the highways for the purpose of private gain. Any other construction of this statute would render it unconstitutional as applied to the citizens or any citizen. The accused therefore moves this court to abate this action, or in the alternative to dismiss the charge against it with prejudice. Pursuant to Federal Rules of Evidence 301 and attending state rule, the burden not rests with the plaintiff to bring forward evidence in rebuttal of any facts stated herein by the defendant with law and great specificity, not merely verbiage and personal conviction and belief of the agency's biased legal counsel. Defendants believe that he has made a compelling case in support of his petition for abatement with sound law and legal theory, and request that if the court rules adverse to that legal theory, that the judge submit a written opinion and conclusions of law defining errors in the defendant's legal reasoning and theory, so that a clear and defined legal obligation of the defendant to comply with existing state statute relative to his constitutional right to travel is understood and established as a matter of law for the accused and the public at large. So, ladies and gentlemen, there it is. There it is. You have a constitutional right to travel. Okay. It is a God-given, natural, objective right. The Constitution protects your right to travel. We've had so many people murdered, jailed, fined, because they thought that they were a driver when they were a traveler. So you got it. In the words of Anna B. Wells, the way you right wrongs is to shine the light of truth upon them. I'll talk to you later.